The law of employment is based on the law of contracts. These contracts represent agreements between an employer and an individual or group of individuals and set forth the terms of wages and benefits, hours, working conditions, responsibilities, and duration of the employment relationship. 3 types of relationships are governed by employment laws. One is the relationship between a person or principal who hires another person or firm to serve as his or her agent to perform a specific duty or service, such as a real estate agent who is hired to sell a piece of property on behalf of the principal. Another type of relationship is that of an independent contractor who is hired to complete a specific job, such as renovation or repair of a building. The most common relationship, however, is that of an employer and employee. Let's take a closer look at some of the primary laws governing this type of relationship. One of the major employment law issues is that of sexual harassment in the workplace.
Nancy, have you finished that memo yet?
Just about. I'm almost finished here.
So, when are you going to make good on that dinner date you promised me?
Jim, I never promised you a date. Besides, you're married. I don't go out with married men.
Oh, come on. Don't be so prudish. It's only a little dinner. And don't forget, I'm the one who recommends you for a raise next month.
That's not really fair, you know. Here's your memo.
Nice suit. Just think about how many new ones you could buy with that pay raise.
Nancy has the right to report Jim's misconduct under her employer's sexual harassment reporting procedure. If it is not resolved there, she may file a charge against the company under Title VII of the Civil Rights Act of 1964. This act prohibits sex discrimination and therefore sexual harassment of both a verbal and physical nature. Should Jim follow through with his denial of a raise for his secretary, or should his misconduct drive her to quit her job, the employer could be liable for lost wages and attorney's fees. Moreover, under the Civil Rights Act of 1991, she may receive limited compensatory damages for such things as mental anguish, as well as punitive damages. Other forms of discrimination are also prohibited under federal law. Listen for improper questioning in the following employment interview.
Have you ever been arrested, Mr. Harris?
Arrested? You mean actually put in jail or something like a traffic ticket?
Anything that would show on your record that we can check?
Well, it's been a long time, you know. I was just a teenager, but a bunch of guys and we got picked up one night for pulling some pranks. It was nothing, it was kid stuff.
You realize, Mr. Harris, that the job in our shipping department requires a great deal of lifting and moving of heavy merchandise. At your age, it's likely that you might find the job too strenuous.
Well, I don't mean any disrespect, ma'am. But just because a man gets older doesn't necessarily mean that he gets weaker.
I appreciate that, and while you state that you are in good health, I do have to ask if you've ever had any medical conditions that might have caused you to miss work in the past.
No, ma'am. Always been in good health.
Have you ever been treated for any emotional disorders?
The interviewer has violated Title VII of the Civil Rights Act. Questions regarding an applicant's arrest record are irrelevant to an employment decision. Conviction records are relevant, however, especially where a conviction relates to the person's ability to perform the job. The interviewer has violated the Age Discrimination in Employment Act, which forbids discrimination against men and women over 40 years of age. She's also violated the Americans with Disabilities Act of 1990, which prohibits employers from inquiring whether an applicant has a disability. An employer may only ask about the qualifications of the applicant to perform essential job-related functions. Title VII of the Civil Rights Act prohibits other forms of discrimination as well. The following scene illustrates an employer's indirect way of finding out about the applicant's family plans without direct questioning by the interviewer.
Judy, this is Susan Manning.
Hi, Susan.
I think she has all the qualifications for the job in our data processing department. Would you follow up with her and fill out the rest of the questions on this form, please?
Sure. Why don't you have a seat, Susan?
Thanks a lot. I hope to see you again soon.
We'll be in touch.
Whew. This was my first job interview. I was really nervous.
Well, it looks like you did pretty well. Now all we have to do is fill out some of the questions on this form. What a beautiful ring. Are you getting married soon?
I hope so. We're talking about setting a date for early summer.
Ah, then I guess you'll want to be taking out our family health benefits package. If you get the job, of course.
Well, sure, I guess so.
Does your fiancé want children?
Yes, in fact, I think he's more eager to have children than I am.
Men are full of surprises, aren't they? Well, I guess this is all we need, and when Miss Jameson reaches a decision, she'll get back to you, okay?
Thank you.
This applicant is unaware that she's being discriminated against due to her plans to get married and raise a family. The personnel manager knows that questions regarding family plans violate Title VII of the Civil Rights Act, so she circumvents direct questioning by this so-called backdoor questioning, setting up conversation between the applicant and her secretary. The applicant is not required by law to answer questions about family status or plans to have children. Here's another illegal line of questioning. It violates the National Labor Relations Act.
Well, James, I guess that just about does it. You have the kind of experience we need at the shop.
I'll sure do my best.
I just have one other question for you. As you know, we run a non-union shop here. Have you ever belonged to a union?
Yes, sir. I belong to the union where I work now.
So you believe in unionization?
Well, I guess I'd have to say I do. I've always worked in a union shop. Really don't know anything else.
The questioning regarding the applicant's views on unionization constitutes an unfair labor practice on the part of this employer. The NLRA prohibits discrimination against employees for union activity. On the other hand, the Act also protects employers from union unfair labor practices. One of the reasons unions were formed originally was to ensure safe and healthy conditions for workers. In 1970, the Occupational Safety and Health Act was passed in order to assure every worker, union or non-union, safe and healthy conditions. The Occupational Safety and Health Administration, commonly referred to as OSHA, is the primary administrative agency with authority to conduct inspections and seek enforcement of safety regulations. Many states have enacted right-to-know laws requiring employers to inform employees of hazardous substances in the workplace. Workers' compensation statutes in every state also provide for medical benefits and limited wage replacement for employees who are injured on the job. When employees lose their jobs through no fault of their own due to, for instance, layoffs or plant closings, they are eligible for unemployment compensation, provided they fulfill certain requirements.
Lynn, there's no question whatsoever regarding your eligibility for benefits since you were laid off because of the plant closing. What concerns me is your full-time student status. With a full load of college courses, how can you be available to work if I find you a placement?
Well, for the past 2 years, I've gone to school full-time and never missed work. I can't afford to go to school without a job. And if there's ever a conflict between work and classes, my job always comes first.
This young woman's situation illustrates a typical problem faced by full-time students who are temporarily out of work. Unemployment compensation benefits are designed to give temporary financial help to persons who lose their jobs through no fault of their own. And the law requires applicants to actively seek employment and remain available for work in the event a suitable job is found. Full-time students have a difficult time proving their availability for work. In the following scene, the interviewer thinks his questions are within the law, but he oversteps his boundaries.
So how was your lunch?
Oh, it was great. The lasagna was perfect.
Good, good. So, do I detect a Canadian about? I always notice that same a boat sound when I listen to Peter Jennings on TV.
Yes, I grew up in Montreal.
Okay, so you will provide us with a certificate of U.S. citizenship, or otherwise I can't hire you.
But I have a state driver's license and social security card. I thought that was all I needed.
Of course, you understand I have to protect the company, so we want a citizenship certificate on file.
Recently adopted immigration laws help to ensure that illegal aliens are not able to take jobs away from U.S. citizens. The Immigration Reform and Control Act of 1986 makes it illegal to hire or recruit unauthorized aliens, and a prospective employee is required to complete a Form I-9 attesting that he or she is either a U.S. citizen or is authorized to work in the United States. The employer is responsible for reviewing the form and supporting documents to verify that the applicant is authorized to work in this country, but a certificate of U.S. citizenship is not required. The state driver's license and social security card are satisfactory documentation. Not all employment laws are designed to protect the employee. As you will see, the employer also has certain rights that are protected by law.
Yeah, let me speak to Larry, please. Yeah, Larry? Listen, I'm about to fax you some stuff on the new generator line. I have the patent applications, the pricing, the distribution plans. Everything we need to know is right here. Now, you want me to make some copies? I can...
This employee has breached his duty of loyalty to his employer and has violated state trade secrecy laws. The employer may dismiss the employee and obtain an injunction against the use of the secret information. In summary, employment law is designed to help employers and employees work together in a mutually beneficial manner and to protect the rights of all parties involved in a formal or informal employment arrangement, including the rights of individuals who are seeking employment. The examples which have been illustrated represent only a few of the most frequently occurring situations. You can learn more about employment laws in the United States by reviewing Volume 29 of the United States Code in your local law library. You might be surprised at the depth and scope of the many labor laws that impact on employment relationships in our country. Knowledge of these laws will help you become both a better employee and a better employer.